All right, you guys, welcome. Welcome to another program of informative information. I'm hoping that you guys find this helpful. So today we're going to talk about, a couple things. I'm going to talk about, I got a question about what we do when we have a family member who is like in a nursing home and not getting good care. What do we do? So we're going to go over a couple things on that today. And I'm going to show you guys kind of how all that works. I'm trying to get sound, light, and everything corrected here. So give me a moment. And then once we get rolling here, I will do my best to keep looking at you, the camera, and keeping my focus on everything that's going on here. So before we begin, Tito, I have a toast for you, my friend, and this is for you.
The following program contains mature content and is the truth. No part herein is intended to be legal advice and is for entertainment purposes only. Audience discretion is advised.
Okay, so I kind of have like part of a screen here, but that's okay. We're just going to have to do with what we got because I don't have like everything completely set up. Today is Mondays. Mondays are real hard for me, guys, because I just got done with class last night. Okay, we just had classes last night, and well, I taught classes, so that's where we are. Today we're going to talk about kind of an off the subject thing, and it has to do with two separate things that this has to do with. This has to do with, first of all, we're talking about somebody, for example, who has a nursing home. There's a nursing home like that is treating someone badly. Let me see what I find. Okay, so I'm just going to look up something here really quick for you guys and show you nursing home neglect. We'll show this. All right, so let me share the screen here, and we'll kind of just go over this really quick. As soon as I can move some of these things around. Okay, share screen, and okay, that's a Chrome tab, my friend. Okay, so we don't need any windows, so I'll just, this is it right here, and sharing. Okay, so you guys can see this is a loved one suffering from poor care. Okay, so make sure you have to report your nursing home. Okay, and the reporting of the nursing home. Oh, this is great. My whole screen just fell. Give me just a second, guys. The whole nursing home is you have to notify the nursing home. But on these things, when you notify nursing homes, nothing's going to happen. You guys aren't going to get any remedy from this. Okay, this is all statutory. Everything you find on the screen is going to be through statutes, rules, and codes. So it's available. This is what is available to people in the public, because your family members have unknowingly waived rights, and you guys have done the same thing. Okay. So this isn't so far-fetched to say that, well, this is just a generational thing and it goes into the next generation, because the same questions you're asking about your folks, this happening to your folks, is going to be the same thing that will eventually fall up on you and other people that you know. So it's important that we go and find out what the problem is and how to fix this problem. So this is a problem that just happens to be a lot of places. And because of the issue being in many places, well, there's more than one concern of people having, issues with these things. When you have a loved one, you try to make complaints and such, but there's only certain things and parameters that fit within that public charitable care. Okay, so when you guys are getting care from somebody or for somebody, but it's from a service, you are limited only to what the rules of the public trust allow that individual to receive, whether it's your stuff or not. Okay, because here's the thing: is you sign something away. If you give something away, you give like a pot of gold away to somebody, and you say, "Here, hold this," and you don't give them the conditions how you want to live, then they're going to create a condition for you. And so that's what's happened: is a condition has been created. it has been presumed, because no one has ever said that I have other rights. So you fall under the same characterizations and classifications as other individuals might. And you are prejudiced because of that. But what are you really going to do about it? I mean, it prejudices you. So when we say, looking at this adult protective services, again, these are all, every single one of these things, when we look here. Okay, so local law enforcement. Okay, guess what you do? You call law enforcement, and then they have a record of your phone number, so that's tracked back to accounting that goes back to your house. Okay, so you've already given an agreement at some point in time to live at your house, and you've given an estate or a piece of your estate away, or permission of that estate to someone else to be able to tell you what to do. Okay, because you have to hand over your rights for someone else to be able to tell you what to do. Okay, that's the only way you can have any rights that are diminished. So when your mom or dad handed over the rights, which is basically a Social Security application, is handing over your rights to your estate. And that's one of them, one of the ways. And so after we hand that right over, then we can't get back into it without creating another situation that is equitable. And that's the challenge, and that's the problem that people are having, is they don't know that other things exist and other remedies exist for you. But we're going to talk a little bit more about that. Okay, so equity jurisprudence is the guardian of fairness. And in legal and, disputes where rigid application of regular law that you just see, the law will say, okay, nope, it automatically goes over here. 2 and 2 equals 4 over here. Red and blue equals green, or whatever, yellow and blue equals green. Okay. And that's just a formula. It's just, that's what the law says. 2 and 2 equals 4, or 2 plus 1 equals 3. It's just, there is no other way around it. Okay. Equity says, okay, 2.96 and 3.2 is, and it gives an exact figure. It doesn't just say this is this and this and this is this. This and this is actually this right over here. It's very much more accurate, you see. So equity will allow that to be done. Within the realm of corporate law, equity plays a role in addressing breaches of corporate charters. And when you guys have people who are, let me say it like this, okay? I'm going to say it as best I can without making it confusing, but the best way I could say it is that someone has a company. When you create a company, all right, you are creating a company that is now under the rules of the state, because you take your corporate charter and you send it to the Secretary of State, and they give you a license, and they say, okay, your corporate charter is approved and it does comply with ours. And there's just a lot of rules that are involved in that. Okay, so the state has their own charter, and then they have several charters under the state. So when you guys go and create a corporation and it's a subsidiary of a state, then you are under their corporate charters. So when a company does something that is against you, you can go to the state and accept the state as the liability holder for the corporation that's under them. Do you understand that? I hope you guys can see that, because that's where your authority and your power is. When you go and you're looking at corporate charters of businesses and you're saying, okay, well, your corporate charter says that, you'll treat people with humility and grace and understanding, and this isn't any of that. So you're violating your corporate charter. And when you bring that into a record, see, they do it all the time. No one ever says anything. So when you bring these into a record, then you have something that you can complain about, okay? When a corporation deviates from its charter, it engages in ultra vires acts, which are actions beyond the scope of authorized power, okay? And these acts are harmful, can harm shareholders. So who do you think in a state of, let's say not confusion where America is right now, but let's say the state of Missouri, okay? The state of Missouri has a corporate charter. And when one of their companies deviates in actions outside of what their own charter says, and it's beyond authorized powers which the state grants them, these acts can harm the shareholders. Now, if you have a Missouri birth certificate, if you were born in Missouri, who is the shareholder? You're holding the certificate. So you're the shareholder, okay? But we're not asserting any rights. We don't assert anything. Okay, so corporate charters are built on the concept of ultra vires, all right? And the ultra vires acts is rooted in the principle that the corporation is a creature of the state. So this creature of the state can only exercise powers conferred upon it by its charter and relevant statutes. And any action outside of these powers is deemed ultra vires and therefore void or voidable. Okay, period. This principle was actually brought out in 1819 in a case by Justice Marshall called Dartmouth College versus Woodward. And Chief Justice Marshall emphasized contractual nature of corporate charter and the limits it imposes on corporate actions. And that's found at 17 U.S. 518, and that's an 1819 case. So ultra vires acts can manifest in various forms, and then this includes engaging in business activities not specified in the charter. So if they don't do something that's specified in their charter, they're acting outside of the scope of their charter. That's not their authority. If they're undertaking financial transactions or commitments beyond the authorized scope of the corporation, if they are ignoring procedures and rules for corporate governance stipulated in the charter, okay, all of these things can, when these things occur, equitable remedies become important and necessary to resolve matters. Equity offers remedies to breaches of these charters, including injunctions, and I've talked about this in my classes, injunctions, specific performance, rescission, accounting, and these remedies, they rectify consequences of ultra vires acts and ensure that these companies stay in compliance with their corporate provisions that they're supposed to be. Injunctions are one of the most potent equitable remedies that are out there, and they address breaches of corporate charters. An injunction is a court order, and it compels a party to do or refrain from doing specific acts. In the context of corporate law, injunctions can be used to prevent a corporation from engaging in an ultra vires activity or to compel compliance with the charter's provisions. So injunctions are classified in different categories, and this is something that I cover extensively in the classes, but injunctions restrain a corporation from continuing or commencing ultra vires activities. For example, if a corporation is engaging in unauthorized business ventures, a prohibitory injunction can halt such activities. Injunctions require a corporation to perform specific actions to comply with its charter. For example, if the charter mandates certain governance practices that the corporation is ignoring, a mandatory injunction can compel the adherence to the practices. The equitable principles guiding the issuance of injunctions were brought out by Lord Eldon in Gee versus Pritchard in 1818. And that's at 2 Swans 402, where he emphasized that injunctions are granted to prevent irreparable harm and ensure the justice is preserved. Specific performance is another equitable remedy that compels a party to perform a specific act, usually fulfilling a contractual obligation, making them perform in the contract. In the context of corporate charters, specific performance can be used to enforce the corporation's adherence to the charter's provisions. For example, if a corporation's charter includes a clause requiring distribution of dividends under certain conditions, and the corporation fails to do so, the shareholders can seek specific performance to compel the distribution. And this remedy ensures that the corporation fulfills its obligations as outlined in the charter. Specific performance is grounded in the equitable principle, that justice requires parties to be held to their contractual promises. And this is brought out by Chancellor Cottenham in Lumley versus Wagner in 1852. And the principle is particularly relevant in corporate law, where a charter represents a fundamental agreement between the corporation and its shareholders. So you guys probably have heard a lot about in the Title 15 and the secured party groups and stuff, rescission or mortgage. Maybe you've had a mortgage video where you've had discussions on rescission of stuff. Rescission is an equitable remedy, and it nullifies a contract and it restores parties to their pre-contractual positions before the contract started. In cases where a corporation engages in ultra vires actions, rescissions can be sought to void transactions and mitigate their effects. For example, if a corporation enters into a contract that exceeds its authorized powers, shareholders can seek rescission to invalidate the contract and prevent any further obligations arising from it. And this remedy helps preserve the integrity of the corporate charter, and it protects shareholders from unauthorized commitments. The equitable foundations of rescission are articulated by Lord Cranworth in Stevenson versus Newham in 1853, where he emphasized that rescission is warranted when a contract is tainted by misrepresentation or exceeds the authority of contracting parties. Accounting is an equitable remedy that requires a party to provide a detailed financial report of its activities. In the context of corporate charters, accounting can be sought to uncover the financial impact of ultra vires acts and to ensure transparency in corporate governance. Shareholders can request an accounting to obtain a comprehensive view of the corporation's financial affairs, particularly when there are suspicions of financial misconduct or unauthorized transactions. This remedy is crucial for making and maintaining trust and accountability within the corporation. The equitable principle underlying accounting was highlighted by Lord Hardwicke in Robinson versus Anderson. That's 1752 case. Where he underscored the importance of transparency and accountability in fiduciary relationships. And the development of equitable remedies for breaches of corporate charters is deeply rooted in historical precedents and the evolution of equity jurisprudence. See, people believe that equity is just some other sort of strange something, but it actually existed in order to fix these problems that came up and arose. So it was an evolution in protection of the law to balance the equities between the parties. In Dartmouth College versus Woodward, the U.S. Supreme Court under Chief Justice John Marshall addressed the inviolability of corporate charters and the limits of state interference. The case established that corporate charters are contracts protected by the contract clause of the U.S. Constitution, and any state law impairing such contract is unconstitutional, or anything that goes against any state law is unconstitutional also. So if you have somebody that's doing something that is against the rules, it is literally unconstitutional, okay? It doesn't apply to you, it applies to them. The landmark decision underscored the contractual nature of corporate charters and reinforcing the need for equitable remedies to address breaches. The principles established in this case continue to influence modern corporate law and equity jurisprudence. In Ashbury Railway Carriage, an iron company versus LaRich, it's an 1875 case. The House of Lords addressed the doctrine of ultra vires in the context of corporate law. The case involved a contract that exceeded the corporation's powers as outlined in its charter. The House of Lords held that ultra vires acts are void and cannot be ratified by shareholders. It can't be okayed. This case highlighted the importance of adhering to corporate charters and the necessity of equitable remedies to address ultra vires acts. It reinforced the principle that corporation powers are limited to those conferred by its charter and relevant statutes. In Foss versus Harbottle, in 1843, the Court of Chancery addressed the issue of minority shareholder rights and the ability to seek redress for wrongs done to the corporation. The court held that individual shareholders cannot sue for wrongs done to the corporation. This is why you can't sue the United States. You can't sue the states. Instead, the proper plaintiff is the corporation itself. However, the court recognized exceptions to this rule, allowing minority shareholders to seek equitable remedies in cases of ultra vires acts, fraud, or where justice requires. This case laid the groundwork for shareholder derivative actions, providing a mechanism for shareholders to seek equitable relief when the corporation's management fails to act. Now, you guys understand that shareholders are beneficiaries or intended beneficiaries. So it's like the beneficiaries have an equitable remedy, and that is the equity court we're telling you about. So the breach of corporate charters and the resulting ultra vires acts pose significant challenges to corporate governance and shareholder interests. Equitable remedies rooted in historical precedents and principles of fairness provide essential tools to address these challenges, and injunctions, specific performance rescission, and accounting offer versatile and effective means to rectify breaches, ensuring compliance with corporate charters and protecting shareholders' rights. The exploration of these remedies and historical foundations underscores the enduring relevance of equity in modern corporate law. By understanding the principles and the applications of equitable remedies, any individuals can better navigate the complexities of corporate governance and seek justice in the face of breaches of corporate charters. For those interested in this subject further, it's the intricate balance between corporate powers and shareholder rights, and it continues to evolve. Equity remains a vital source of fairness and justice in addressing the breaches of corporate charters. So these, the citations of this are already named, and I'm going to kind of expand on this a little bit, okay? So corporate charters were historically known as articles of incorporation, okay? So now you know what that is. An article of incorporation is a corporate charter. So when you say, can I see your articles of incorporation, or where can I find your articles of incorporation? And they've been fundamental to the formation and governance of corporations since the medieval era. In early English law, these corporations were established by royal charter, which provided legal framework which they could operate. And the legal framework was essential for ensuring that corporations acted in their designated purposes and didn't exceed authority granted to them by the sovereign. As corporations evolved, especially during the Industrial Revolution, the need for more standardized and accessible process for corporate formation became really clear. The incorporation process shifted from royal charters to statutory charters, where corporations could be formed under general incorporation laws. This democratization of corporate formation enabled more businesses to incorporate, fostering economic growth and innovation in their eyes. Okay, I didn't say that, but that's just the way it works. That's the way that formation of business works. The importance of corporate charters extends beyond merely outlining the corporation's powers and purposes. They also serve as a mechanism for protecting the shareholders' rights and interests. By clearly defining the scope of the corporation's activities, the charter provides shareholders with a predictable framework within which the corporations will operate. This predictability is crucial for maintaining investor confidence and encouraging investment in corporate enterprises. Corporate charters also include provisions related to corporate governance, like, for example, election of directions, the conduct of shareholder meetings, and the issuance of stock. And these governance provisions are essential for ensuring that corporation is managed in a manner that aligns with the interests of the shareholders, and it complies with legal and regulatory requirements. I talked about earlier the doctrine of ultra vires. Ultra vires means beyond the powers in Latin. Okay, in English it means beyond the powers. It's a Latin word. It is a fundamental principle in corporate law, and the doctrine holds that any action taken by a corporation that exceed its chartered powers is null and void. And it's behind the fact that it ensures corporations don't engage in activities that weren't authorized by shareholders or by the state. And the doctrine was, in the past, has been strictly enforced, and any act beyond the corporation's powers was deemed invalid. And the strict enforcement served to protect shareholders and third parties from unauthorized corporate actions. However, over time, courts and legislatures recognized the need for a more flexible approach to the doctrine. One of the key developments in this regard was the introduction of the constructive notice rule. Under this rule, third parties dealing with a corporation are deemed to have constructive notice of the corporation's charter and are expected to ensure that the corporation is acting within its authorized powers. The rule provides an additional layer of protection for shareholders by placing the onus on third parties to verify the corporation's authority. That's your responsibility, guys. In modern times, the ultra vires doctrine has been significantly relaxed. Many jurisdictions have adopted statutory provisions that allow corporations to engage in lawful business activity, thereby reducing the likelihood of ultra vires acts. Nonetheless, the doctrine remains relevant in certain contexts, particularly when dealing with specific limitations imposed by the corporate charter or state law. You guys understand that that's where it starts getting into a fine line. When you say you're a status and they are treating you as another status and they're not acknowledging it, that's outside of their corporate charter, right? Because it says that they will honor and respect with dignity their shareholders, right? You just got to have this stuff to call them out on. Injunctions are cornerstone of equitable relief in corporate law, and they provide a mechanism for ongoing or imminent breaches of the corporate charter and compelling compliance with its provisions. The process for obtaining an injunction usually involves demonstrating that there is a clear legal or equitable right that needs protection, that there is a substantial likelihood of success on the merits of the case, and that the risk of irreparable harm if the injunction is not granted is great. And the balance of equities favors the granting of the injunction. In other words, it will balance the parties if it's granted. In the context of corporate charters, injunctions can be particularly effective in cases where a corporation is engaging in unauthorized business activities. For example, if a corporation chartered to operate as a manufacturing company begins engaging in speculative financial transactions, shareholders can seek prohibitory injunction to halt these activities. The case of Attorney General versus the Great Eastern Railway Company in 1880 illustrates the application of injunctions in corporate laws. And in this particular case, the House of Lords granted an injunction to prevent the railway company from undertaking activities beyond chartered powers. And the court emphasized the importance of adhering to corporate charter and protecting shareholders from unauthorized actions. Specific performance, again, expanding on this, it's equitable remedy that compels a party to fulfill its contractual obligations. In the corporate context, specific performance can be used to enforce provisions of the corporate charter, like distribution of dividends or execution of specific governance practices. The remedy of specific performance is particularly relevant where monetary damages are inadequate to address the harm caused by the breach. For example, if a corporation fails to distribute dividends as required by the charter, shareholders may suffer financial harm that cannot be fully compensated through monetary damages alone. In such cases, specific performance ensures that corporations fulfill its obligation as outlined in the charter. So let me explain one of those examples. If shareholders can suffer harm that can't be fully compensated, say somebody does something and you pay them on time, and they say you didn't do something properly, so they didn't report your credit report properly. Okay, so now, they're like, oh, well, we'll fix it back to the way it is. Well, it doesn't change anything that other people have this credit report that you got denied for. So money can't just solve that. So they create other things outside of the money that they can give for remedies. Okay. So in Fry versus Lane in 1888, the court, Lord Kearns, emphasized that specific performance was warranted when it is just and equitable to compel a party to fulfill its contractual obligations. The principle is especially pertinent in corporate law, where a charter represents a binding agreement between a corporation and its shareholders. And again, rescission is equitable remedy that nullifies a contract and restores the parties to their pre-contractual positions. In the context of corporate charters, rescission is sought to invalidate ultra vires transactions and mitigate their effects. For example, if a corporation enters into a contract that exceeds authorized powers, shareholders can seek rescission and to void the contract and prevent any further obligations arising from it. This remedy is crucial for protecting shareholders from unauthorized commitments and preserving the integrity of the corporate charter. If corporations are going and making obligations or they're signing away rights to other companies and it's making the shareholders suffer, then people have a right to stand up and fix it. It is now 3:33 here. The case of Central Transportation Company versus Pullman's Palace Car Company in 1891, demonstrates the application of rescission in corporate law. And U.S. Supreme Court held that contracts exceeding the corporation's charter's powers were void and subject to rescission. The court's decision reinforced the principle that the corporations must act within authorized powers and that ultra vires acts are null and void. So what do you guys think when somebody, when you send them something and they don't listen to you? What do you think that is? That's an ultra vires action. It's voidable. Okay? It's null and void. So you have to make the record that it's null and void. Accounting is an equitable remedy that requires a party to provide a detailed financial report of its activities. In the context of corporate charters, accounting can be sought to uncover the financial impact of ultra vires acts and ensure transparency in corporate governance. Shareholders can request an accounting to obtain comprehensive view of the corporation's financial affairs, especially when there are suspicious or financial misconduct or unauthorized transactions. This remedy is important for maintaining trust and accountability in a corporation. The principle underlying accounting were articulated by Sir George Jessel in Russell versus Wakefield Waterworks Company in 1875, where he emphasized the importance of transparency and accountability in fiduciary relationships. And the principle is particularly relevant in corporate law, where shareholders rely on accurate and transparent financial reporting to make informed decisions. The development of equitable remedies for breaches of corporate charters is deeply rooted in historical precedents and the evolution of equity jurisprudence. Key cases on this are, and legal principles from these are, one of them is Dartmouth College versus Woodward. The court addressed the inviolability of corporate charters. Okay. Chief Justice John Marshall, writing for the court, held the charter was a contract protected by the contract clause of the U.S. Constitution, and any law impairing such contract was unconstitutional. The landmark decision underscored the contractual nature of corporate charters and reinforced the need for equitable remedies to address breaches. Marshall's opinion emphasized the importance of adhering to terms of the corporate charter and protecting the rights of shareholders and other stakeholders. The principles established in this case continue to influence modern corporate law and equity jurisprudence. In Ashbury Railway Carriage and Iron Company versus Rich, the House of Lords addressed the doctrine of ultra vires in the context of corporate law. The case involved a contract between Ashbury Railway Carriage and Iron Company and Rich for the construction of a railway. The contract exceeded the corporation's powers as outlined in its charter, which was limited to manufacturing and dealing in railway carriages and iron. The House of Lords held that ultra vires acts are void and cannot be ratified by the shareholders. The court said that corporations' powers are limited to those conferred by the charter and the relevant statutes. The case highlighted the importance of adhering to corporate charters. The principle established in Ashbury Railway Carriage and Iron Company versus Rich continue to influence modern corporate law, especially in the context of ensuring that corporations act within their authorized powers. The case underscores the role of equity in providing remedies to these. So Foss versus Harbottle expanded on this, as the Court of Chancery addressed the issue of minority shareholders' rights. So you guys are also shareholders, and your ability to seek redress for wrongs done in corporations. So the case involved two minority shareholders, Foss and Turton, who sought to sue the directors of the Victoria Park Company for alleged misconduct and mismanagement. And the court held that individual shareholders cannot sue for wrongs done to the corporation. Instead, the proper plaintiff is the corporation itself. Okay, so what is this really saying? What is this really saying when it says the proper party is the corporation itself? So you can't sue the state of Colorado if you were born in Colorado, but you could sue John Henry Doe. Does that make sense? I hope you guys get that. So that's Foss versus Harbottle. Okay, so the groundwork for shareholder derivative actions provided a mechanism for shareholders to seek equitable relief when the corporation's management fails to act. The case is the role of equity in protecting minority shareholders' rights and ensuring that corporations are held accountable for their actions. So the breach of corporate charters and resulting ultra-vires acts pose significant challenges to corporate governance and shareholders' interest. Okay, the equitable remedies rooted in historical precedents and principles of fairness provide necessary tools to address the challenges. Injunctions, specific performance, rescission, accounting, they offer versatile and effective means to rectify breaches and ensure compliance with corporate charters and protect the shareholders' rights. In the exploration of these remedies and their historical foundations, it underscores the enduring relevance of equity jurisprudence in modern corporate law. By understanding the principles and applications of equitable remedies, individuals like you and I can better navigate the complexities of corporate governance and seek justice in the face of breaches of corporate charters. For those interested in delving into more, the intricate balances between corporate parties and shareholders' rights continues to evolve. And equity maintains a vital source of fairness and justice in addressing these breaches and charters. So if you guys have more questions on the subject, I want you to absolutely do reach out and let us know. I've got to find something else here that I was working on because I want to address that with you guys really quick. I'm not sure that I'm going to be able to find this, though. We shall see. All right. Let me see if this is one of them. All right. So I think this might be it. Okay. So I'm going to go over a couple of things here. Let me move this so it doesn't look like I'm ignoring you guys. Well, that wasn't good. I didn't like what that did. Let's see. There we go. Okay. Okay, cool. So let me go, and we're going to talk about the nursing home situation, okay? We're confronted with an unfortunate scenario of elderly individuals in a nursing home who have become victims of neglect, and they were intended not to be the responsible parties they were not supposed to be in the public trust, and they were misclassified. And, well, here's where we are. So when you have problems like this, the best thing to do is go seek an injunction. I would tell you guys, like, the thing that I would personally do is I would go do a little research and try to find out about, a corporate charter for a company. All right, that's what I would do. And you know what? Tomorrow I'm going to show you, I'll show you guys some things on how to look up some corporate charters, how to find corporate charters. So I'll go over that if you guys have questions on that. Because this is about, like right now, where it's about creating a situation where we can get things done, like start accomplishing some things. And I don't think it's too late ever, to put a corporation in its place, because they're staying like open for business to keep usurping off of people, right? So they clearly know what's happening. So equity regards substance rather than form, and it'll correct a mistake to reflect the intention of the parties. A constructive trust could be imposed to remedy the improper way that the property is being distributed right now. The remedy is designed to prevent unjust enrichment, and it ensures that the property is held in the benefit for the rightful beneficiaries. In this case, it would involve recognizing that a nursing home or other party holding the assets in error are actually holding them in trust for the intended beneficiaries, like the elderly parents or grandparents or whatever. Equity will not permit a statute to be used as an instrument of fraud, and it will raise a constructive trust to prevent such as an outcome. And that's a course of lectures by Maitland on equity, page 78, that citation. Reformation is an equitable remedy, and it allows the court to amend the terms of a trust to reflect what the actual intended by the parties at the time the trust was created. The remedy is relevant where there's clear evidence that the person, like the elderly individual, was intended to be a different party, not a trustee. So reformation of that trust ensures that the trust documents are aligned with the true intentions. Now, the other part about this is that they have Social Security. They're receiving Social Security benefits, so they've locked themselves out of the potential possibilities that they could have. So there has to be other things and at least intention created before you guys can move forward on this. A resulting trust can be declared where a trust fails to reflect the beneficial interest intended by the parties. And it occurs where the equitable interest is presumed to revert to the grantor, or in this case, to the intended beneficiaries due to the failure of the original trust purpose. And this remedy acknowledges the initial intent and adjusts the beneficiary ownership accordingly. A resulting trust arises where equitable interest in property returns to the grantor where the trust fails or is incomplete. And that's the 18th edition on Lewin on Trusts in page 123. 123. So you guys are going to have to create, in order to resolve these, you need to create a suit in chancery. And you're going to have to, like, there's more to that. You can't just, I can't explain it on a video because it's not appropriate, first of all, and it's not something, this isn't a teaching platform. It just isn't. So you guys, like, the citations that I give you guys are all stuff that is available here, and you guys can go look that stuff up. I encourage you, because when you start digging into these citations that I give you, you're going to see that it's going to open up other doors for you and other questions for you, and you're going to want to go seek other answers. And I'm not always, I'm not the answer here, guys. I'm not. I'm just showing you guys what's available out there for you guys to see. So you don't have to, you don't have to, like, try to go reinvent a wheel. I'm not trying to, like, create something where you guys have to go figure something else out. So I'm leading you right to where it is. We're going to talk about some remedies with, remember that all municipalities, the city that you live in, the county that you live in, the town that you live in, if that's what it's called, they all have corporate charters, and they are all operating under that corporate charter. And I promise you, they're all breaking them. It's just you finding out where these exist and what they are. And once you guys figure that stuff out, you're going to really see that that you have rights. So let's see. I'm just looking at the comments because I don't have any more, guys. I'm just really putting up here like what I've got right now and what I'm going to get you guys, because it's not really hard. It's not hard. You just have to learn the equitable stuff. You got to learn the equitable principles, how to approach these people, how to create an agreement with them, and how to bind them so that they are bound. Because they're like, literally, imagine this, all right? The same way that you walked up to a driver's license window and just signed a thing because there's nowhere to, like, negotiate that thing, is the same what you did with when you walked up and got everything else. So that stuff can be all fixed, but you got to know what you did and know who you are and know how to fix it. Once you know those few things, then everything else will just fall into place for you, because it's not a question of who you are. We already know you guys are badasses. We already know that you guys have the ability to do all this stuff. We already know that you guys created all this havoc and you're just living in it right now because you're in your own stuff. But the question about it is like, and we can talk about problems all the time, but these are solutions. These are how you get to solving what you've created, the things that you've created inadvertently. Now you can go undo them, but it's a matter of asking questions. So you start asking people, what's going on or what's happening, then you're going to start getting answers. And when you start invoking equity and dragging them in at equity, they don't want to be there because they already know the pendulum's like this. They already know they got you. So when you bring it back to this, they don't want that. That's not what they want. All right. So let's see. I'm in the Telegram. All right. Okay. Okay. It can't. Okay. So somebody's got just a comment that you made. Anyway, you guys, I don't have anything more because this is kind of a sporadic show that I did. Just a kind of a quick thing. I did get quite a bit done today in my own personal stuff, and I had 3 consults this morning. So that was it's been a productive day, and I'm grateful for all you guys. So I appreciate you guys. You guys have an amazing day. I send you much love and energy. I hope that you guys got a lot out of this. I know that it was kind of short notice. I literally put this together like 30 minutes before this show started. So what I just gave you guys is something that I just slammed together as fast as I could. So like, be easy on me. I'm grateful. You guys have an amazing day. Again, I appreciate you guys very much. And I'll see you again tomorrow. I yield.